mention one matter.
Yes.
Milord, I have filed an IA in writ petition 342 of 23, Milord. So, Milord, my client is a army personnel, Milord, he's a GD. Milord, he is permanently disabled to some extent and is being transferred, Milord. So, the writ petition a few months back was disposed of as settled, Milord, whereas my client had no knowledge that his advocate had instructed the court that the petition has been settled, Milord. So, accordingly, it was disposed of. I filed an IA to restore that writ petition and recalling of the order, Milord. So, Milord, I seek urgent listing of that IA, Milord, because he has transfer orders for 28th
Get local counsel to file a mention memo. Yes.
Milord, it has been filed, Milord.
We list it next week, yes.
Pardon, Milord?
Next week, list it next week, yes.
Milord, on 28th, he has transfer orders, Milord, and they are sending him to high altitude, Milord.
28th?
On 28th, he has transfer orders and they are sending him to high altitude, Milord. That is why there is an urgency.
List it after this.
Obliged, Milord. Deeply obliged.
Please, Your Lordship. I'd like to mention item number 41, Your Lordship. Number 41. The hearing list.
41. Yes. Apiona Jorberin Sani.
I have informed my counsel for the petitioner also.
Yes.
Some personal difficulties.
Oh, when?
After 2 weeks, Your Lordship.
Okay, 2 weeks, yes.
Obliged, Your Lordship.
If it please, my lord.
Item?
I beg to mention item number 44, my lord. I pray for 2 weeks' time.
On behalf of?
E.G. Moomin, my lord.
Where's E.G. Moomin?
He's in the other court, my lord.
Don't say that. This court today is the senior most court in the court. He's supposed to be here. Anyway. Yes, Mr. Jindal.
Your Lordship, 2-3 times they have taken, let it be 1 week.
1 week, yes. Yes.
Please, Your Lordship, item number 46, Your Lordship. Let the matter be listed after 2 weeks, Your Lordship.
No objection.
He's for the petitioner.
I'm for the petitioner, Lordship.
Who's for the petitioner?
He's for the petitioner, Lordship.
You have no objection?
No objection.
No objections.
Why, Mr. Walang? You have few matters.
No, not feeling well, sir.
Not feeling well? You're looking fit and fine.
Yes. Highly obliged.
Yes.
Your Lordship, I'd like to mention item number 43.
Yes.
Pray for 3 weeks of time.
3 weeks. Yes. This senior counsel is not well. He's under an operation or something.
No objection, Your Lordship.
Mr. Kanta is not here in the matter also.
May I please, Your Lordship? Your Lordship, I'd like to mention item number 45.
Number?
45, Your Lordship.
On behalf of Mr. Hassan?
S.K. Hassan, yes, Your Lordship.
No objection, Your Lordship.
After?
2 weeks, Your Lordship.
2 weeks.
Highly appreciated.
Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 45 or 47, Your Lordship.
Yes.
Madam, I'm for the respondents. No objection. She has
The matter after 2 weeks, Your Lordship.
2 weeks.
Much obliged, Lordship.
Your Lordship, I would like to mention item 42. Your Lordship, the arguing counsel has some personal difficulty for hearing.
Who's the arguing counsel?
PR, Mr. Paske.
Mr.
P. Roy Paske. For respondent number 3.
No objection, Your Lordship.
2 weeks.
Bless Your Lordship.
Supplementary list, item number 1.
May it please, Your Lordship.
1 second.
Item 1, 2 and 3, my lord, they are all connected matter, and my lord, the issue is common in all 3 matters. Item 1, 2, 3. Your Lordship, may kindly see item 3 first, because item 3 is a complete matter, my lord. Item 3. In all these three matters, my lord, the order has been passed by single member, my lord, whereas the matter was heard by two members. Your lordship, kindly see the order of the commission, my lord, which is at page, first is, my lord, 217, my lord, page 17.
Page 17?
17, my lord, and relevant page is at page 25. Page 25 is the relevant page, my lord.
Yes.
And if your lordship will see quorum after the title of the case, quorum is R.K. Soni, Principal District and Session Judge, retired member. So this order has been passed by my lord, one member, my lord. Now your lordship will see
who is R.K. Soni? He's appointed
R.K. Soni he is a member of MSERC, my lord, member legal of the MSERC, my lord. Whereas the matter was heard by chairperson as well as member legal, my lord. Chairperson, my lord, got retired on 12th May, my lord, and the order has been passed on 6th June, sitting singly by the member legal, my lord. Quorum as per the commission's requirement is that it has to be two, my lord. And kindly see the date of the order, my lord, which is at page 266, my lord. 213, my lord. 213, my lord. 213.
Every day.
213.
Yes.
And the matter was heard by
213. 1 second.
213, my lord, and the date of hearing is 20th March 2024. Matter was heard by chairperson and member MSERC, my lord, present, if your lordship will mark after this. And then at 214 also, my lord, matter was heard on 20th March 2024 by chairperson, and the order I have shown, my lord, order has been delivered on 6th June in both cases by single member, because the chairperson retired on 12th May 2024. Law is, my lord, if I show the regulation, my lord, regulation is that quorum has to be of
where we annex the
regulation. We have separate copy, my lord, the regulation and everything. And kindly see regulation 10, my lord.
Who's appearing for the side?
No, the copy has been served, my lord, to MSERC by email yesterday evening, my lord. I'm told that the copy has been served, my lord. So it's a case of quorum non judice, my lord. Quorum regulation 10, your lordship may kindly say.
Yes.
Where the commission has also one member or more, the quorum of any meeting shall be two, including the chairperson. So it's a case of quorum non judice, and your lordship's order is also there, citing quorum, the very this provision, my lord, which I have annexed at page, my lord. It is part of the compilation, my lord, and it is there at page. And kindly see provision 3 also of this 18.3, my lord, of the provision, my lord, 18.3 of the regulation. It says all orders of the commission shall be signed and dated by chairperson and members hearing the matter, and shall be altered except to correct the apparent error, my lord. So, and it is not signed by the chairperson, my lord. The order could not have been signed because he stood retired, my lord. So, having regard to the fact that it is an order by a person who is member only, and he is not commission, my lord. Commission is always more than one, my lord. So this order is passed by the authority which is called quorum non judice, and the law on this issue is settled, my lord, that one who hears the matter should decide the matter, my lord. The matter has been heard by chairperson and member legal, my lord. Matter was not decided by chairperson because he stood retired on 12th May, my lord. And therefore, my lord, it is a case of quorum non judice. Kindly see the 18.3 is clear, my lord. Regulation 10 is clear, my lord. And therefore, the order passed by member is not the order of the commission. So, case of the these electricity distribution, generation and transmission company before your lordship is that the order passed is wholly without jurisdiction. It is an order without jurisdiction, my lord. and it has got far-reaching consequences for the corporation, my lord, which the data has been captured, my lord, at page 262 of the petition, my lord. 262 of the petition, my lord, where the kind of loss has been calculated if this order is given effect to, my lord. One is 726 crore rupees, my lord. 262, my lord. If this order is given effect to, my lord, at page 266, my lord.
Yes.
And the loss will be to the tune of 726 crore rupees, my lord. Middle of the page table is there, my lord, where summary of impact of individual component on AARR, my lord. This is one loss, 726, that 266, my lord, 726 crore rupees, my lord. And the second loss will be at 273, my lord. Last page of the petition, my lord.
Mr. Ekumalan Advocate General appearing for the petitioner, stop issue notice to the sole respondent, returnable in 2 weeks. Stop the Learned Advocate General has drawn attention of this court to the order dated. That's page 17. Order dated
6/6/2024.
6/6/2024, which he contends.
And 5/6 also, my lord. There are two orders. 5/6/2024.
6/6/24 and 5/6/24, which he contends has been passed in violation of regulation 10 and 18.3, which prescribes that the commission, the quorum for the commission should be at least 2 into the chain of chairperson, and wherein at 18.3 it has been specifically provided that all orders of commission shall be signed and dated by the chairperson and members hearing the matter, and shall be altered except to correct the apparent error. It is further submitted that the impugned orders herein have been passed by the sole member, one R.K. Soni, Principal District Sessions Judge, retired. On his sitting singly. It is also sitting singly in as much as the chairperson had retired on
12th May 2024.
12th May 2024. Stop. Next paragraph. On hearing senior counsel, prima facie, it appears that the matter deserves further consideration, and that at this stage interim orders are called for. Accordingly, in the interim, next paragraph, the impugned order dated 6/6/2024 shall remain stayed until the next date, please.
Grateful.
Item number 4.
Number 4, ozone engineers. Yes.
What is
this?
limited issue
MECL.
here? MECL.
They become a major
Litigant.
litigator. Yes.
Well, it's on 10/3/2023, one tender was floated by MECL.
On 10/3/23.
The lordships would find out at page 38, the relevant portion. This is the scope of work,
38.
If I may just take your lordships first to page 18 once.
Page
18, that's the opening of the NIT,
Yes.
This is 10/3/23, Meghalaya Power Transmission Corporation Limited is inviting tender from interested eligible bidders for construction of 132 kVA transmission line along with so-and-so blame implementation of SAS and related services at 132 kVA grid substation, Nongol Bibra. Tender details are available at so-and-so. So this is the scope of work in Nongol Bibra, Millets. Now, petitioner Millets had participated in this tender. He was found techno-commercially suitable, Millets, and he was also the L1.
Techno-commercially, financial
both. It was in two parts. One is the technical part, one is the commercial part. So in the technical part also he succeeded, Millets, in the commercial part also he succeeded. That your lordships would find at page 606. Annexure 12, page 606 minutes. The lordships have it.
Yeah. 606. Yeah.
My lords, your lordships, if I may just skip 1 to the third paragraph.
This is dated?
My lords, this is dated 11 July.
So tender was on 10/3.
My lords.
10/3/23.
July 23, my lords.
This is 11 July 11/7/23. Yes.
My lords. It says, my lords, that the chief engineer further informed for approval of the opening of the price bid of the qualified bidders has been received from the competent authority. The qualified bidders are so and so. My lords, I am at serial number 1. Your lordships would see.
Okay, yeah.
Ozone. My rates, my lords, the rate is down below. I have quoted 44 crores, 68 lakhs.
Yes.
The others are quoted 47 and 46 crores, my lords.
Okay.
Now, this tender, my lords,
yes,
was never settled, and in spite of the techno-commercial bids being opened, my lords, the tender has been kept pending. That your lordships would be established from page 609. If your lordships kindly have a look at page 609, annexure 15.
So empowered committee, what is empowered? Is the tender committee? What
Is the tender committee?
It's a tender committee.
Is the tender committee.
So examine the price bids and compare statement. Okay, then.
If your lordships, before I go to annexure 14, my lords, annexure 15, if your lordships kindly have a look, page 609.
Yes.
But this we've taken from the portal of MECL. Your lordships would see this is dated the 20th of June 2024. That is yesterday, my lords. Day before yesterday.
No, 2014 or 15.
Annexure 15 at page 609.
Yes.
My lords, so as on, my lords, 20th of June 2024, this tender is alive, my lords.
20th
June. Yes. On the top right hand corner, your lordships would see, my lords, 20th June 2024 at 1:16 p.m. this has been taken out. So, my lords, this tender is very much alive. This is the same tender, my lords. Your lordship will see tender title, construction of 132 kVA transmission line with so-and-so, along with so-and-so, and related services grid station, Nangal Bibra on turnkey basis.
Yes.
Now, what has happened is why we are before your lordships is, my lords, while the tender is alive,
but it's not been decided.
It's not been decided, my lords, pending. At page 608, my lords, annexure 14.
Yes. Prior to 20th.
My lords, this is only for the purposes of showing, my lords, that the tender is alive. On the date of filing of the writ petition, the tender was alive, the earlier tender. At page 4, annexure 14, page 608, my lords, we kindly see there's a new NIT at serial number 1, my lords, scope of work. It says construction of 132 kVA DC line for upcoming Nongol Bibra ISTS substation to existing Nongol Bibra MPDL substation with HTCL conductor. This is the same work, my lords.
Sure. It is the same work.
It is a part of that same work.
Let us see,
I'll take your lordships to that exact statement, my lords. Your lordships would find that at page 38.
You mean they've retended a portion of the work?
My lords.
Page
38. NIT starts from page 18, my lord. Scope of work at page 38, your lordships will see.
Yes.
Well, it says construction, supply, erection, testing and commissioning of 132 kV double circuit line which HTLS from so-and-so 132 kVA substation Nongol Bibra ISTS to 132 kBs substation Nongal Bibra MEPTCL.
But this is construction of 132 DC line from upcoming to 21 and 132.
It's the same one. This was
112 kV
only
line.
that word upcoming is not there. Your Lordship will see from it is from substation.
No, but is it how can you satisfy the court that this one is not a supplement to the earlier tender?
It is not a supplement.
It's upcoming from so and so. It's upcoming. Your 132 lines upcoming.
My lords, I'll show your lordships. Your lordship will kindly see. It is from substation Nongol Bibra ISTS. Your lordships would have seen that at page 38, my lords.
Yes.
To substation Nongol Bibra MEPTCL. So it is from Nongol Bibra ISTS, my lords, to Nongol Bibra substation of MEPTCL at page.
Just read. This one's construction, supply, erection, testing, and commissioning of 132 kV double circuit line. Okay, double circuit line with HTLS from 220 132 kV substation. This one says construction of 132 from upcoming so-and-so line.
130, because my lords, when we create that line, this
not a
this
technical
is,
person.
I'm sorry.
We'll have to take expert opinion.
My lords, my only case before your lordships at this stage is, while that earlier tender is pending, my lords, they could not have issued a fresh tender.
Appearing for the
and my lords, I just want to draw your lordships' kind attention. What they have done is, my lords, they have broken up the tender into various parts. If your lordships kindly have annexure 13, page 607.
Yes.
This is my lords, office order of the respondent corporation itself, my lords. This is dated the 4th of April 2024.
Who violated the financial powers?
My lords, this is what is happening. This is what I'm pointing out before your lordships. One work is there, my lords. Now what that is split up while the tender is pending. Work is split up and then it is given. So it is because of these reasons their own office order is there. And your lordships may kindly see what it says. It has been observed that while tendering so-and-so under the 3 subsidiaries, there are certain incidents of violation so-and-so. My lords, I'll skip this. Now this is to bring to your notice of all concerned officers of MECL and its subsidiaries that there shall not be any incidents of splitting of works, schemes, projects as restricted, not permissible under clause 12A of the delegation of financial powers of the chairman and other officers of MECL, failing which appropriate action shall be taken. So splitting of work, my lords, they themselves say is not permissible. While the work is pending, my lords.
Who's appearing for the respondents? Nobody.
Fellows, I am there for the MECL, but fellows, I have checked with the corporation. The copy of the petition has not been served.
My lord, I have requested my friend also the other day to serve the copy to corporation.
We wanted to serve, they've not received, accepted it. That's what I'm instructing.
My lord, that was to me. I have requested them to serve to the office, my lord, which my friend is also saying that they have not served to the office. We have inquired.
Serve copy, yes, sir, Mr. Capel. As there's no representation from the side of the respondents, petitioner to serve copy to the itself, disseminate after.
Since MECL has now become a major litigant, it's but natural they should have a standing council where we can serve copies.
That is departmental's choice. I know they don't want to.
We can't be running to Delhi with copies every time.
I can take the copy.
E-service, we should start.
We'll do that.
Our law officer is always available, my lord. They could have approached him.
Yes.
Please, your lordship. Your lordship, my case is that the private respondent number 3, your lordship, has filed an application.
So that is number 3.
He is the private respondent, the secretary of the Rajbhavan, your lordship. Your lordship, he has filed an application before the chief forest officer, who is the respondent number 2, your lordship, chief forest officer JHADC, for registration of Allow Re Sumar. This is at annexure 1, your lordship. Kindly produce annexure 1. The translated copy is at page 30. Your lordship, subject a formal request to register the Allow Re Kinti private forest and Allow Re Sumar forest, religious forest named Amsiar Abdu Amrawan, which is situated at Ilaka Amwi. Your lordship, kindly note that the address mentioned above is at to the chief forest officer JHEDC through the Daloy of Ilaka Amwi.
Okay.
Now, in reply to this application, your lordship, the chief forest officer has issued one notice. This is at annexure 2, page 32, your lordship.
Yes.
The CFO has issued the notice dated 26/10/2022. Your Lordship, whereby in this notice, public notification is issued to the public for intending the registration of this forest, and this notice was issued only to the Daloi of Ilaka Amwi, the secretary, who is the respondent number 3, and the assistant forest officer.
Who are you?
I am the Darbar Shnong, Your Lordship, and one private respondent. I'm affected by this notification.
Why, is your village inside the forest?
Yes, Your Lordship, because notice was not issued to me. Your Lordship, kindly come.
What's a huge piece of land, Mr.
Your Lordship, they have violated all the provisions.
5,000 hectares.
They have violated all the provisions of the Forest
What
Act.
happened after that? They registered
After that, what happened? They registered the forest, Your Lordship. Your Lordship, that is at Annexure 3, page 35.
Annexure?
Annexure 3, page 35, Your Lordship.
Okay.
Your Lordship, kindly look at point number 5, Your Lordship. In the event new application is received by the registering office for registration of pieces of land within the boundaries of Raj Buwam, the same shall be subjected to the approval of the Raj Buwam. Your Lordship, initially the application is for 50,300 hectares and the registration is for 5,226 hectares. Even the boundaries have been changed from the application form, Your Lordship.
Applications of 50,000 hectares.
Hectares, but they registered for 5,226. Even the boundary northeast southwest, that also has been altered in the notification.
Not what movie is what meant to do. Amcharian, Leshkar Dam.
Now, Your Lordship, what happened after this? It was only in December, Your Lordship.
No, then if you are a resident inside, you didn't see them coming to.
No, Your Lordship, because at the time this happened in December, because it was only last year, Your Lordship, that the activity had taken place. Then only we came to know.
But this is 8/12/22 registration.
Yes, Your Lordship, but we were not aware. Public notice was not issued to us. I'll take Your Lordship to the sequence of events. What happened after this, Your Lordship? We came to know about this only in December last year, to 2023. So all the villages under Ilaka Amwi, Your Lordship, they filed a application objecting against this notification, registration of this
It's registered as a private forest.
Lowry Sumar, as per the rule and the act, it's a private forest, Your Lordship. So what happened? We filed this representation. The petitioner number 1, which is the
Annexure 4.
Annexure 4, yes, Your Lordship. The petitioner number 1 and the adjoining villages under Ilaka Amwi, we filed the objection. Then the petitioner number 2
that
also.
means this Thanguli village, this
Umladpur
all
village,
affected.
Jaranj, Kentalang village.
Also.
Yes, Your Lordship. They are all affected by this notification. Now, the petitioner number 2, Your Lordship, she is a private respondent. Her land does not even fall under Raj Buwam. It falls under Raj Amwi. It's a completely petitioner number 2.
So why clubbing it together with the
Yes, Your Lordship, because notice was not issued, survey was not conducted.
No, she's got a separate cause of action for herself. Number 2, she can go for the Darbar.
Your Lordship, but then you know, Your Lordship, because in reply to these objections, Your Lordship, the CFO has called all of them together, Your Lordship. A meeting was held. And in the meeting also, Your Lordship, this is an Annexure 6, Your Lordship. In the meeting itself, the CFO has stated that notice was not issued to any of the party. And one important aspect, Your Lordship, I would like to point out, Your Lordship, kindly peruse the Waheshnong Act of 2015, Your Lordship.
What does it say? So you filed a representation on what happened?
What happened in this meeting?
The objector registration, what happened? How did they reply?
They call us for a meeting, Your Lordship. In the meeting, they've clearly admitted that we did not issue notice to you. That we have registered the land based on the recommendation of the former Daloi issued 45 years ago, Your Lordship. Whereas the Act clearly states that recommendation of the present Daloi is required.
No. I mean, how did they reply? Have they?
No, Your Lordship. No order was passed. Meeting was called. Objection was heard.
When was the last meeting held?
That was the only meeting, Your Lordship. That was the only meeting.
What about this Annexure 10?
Yes.
Oh, that's RTI. Okay.
No, Your Lordship, the meeting was on the 6th of December last year, 2023. In that meeting, Your Lordship, no order was passed. Only the objections was heard. The CFO, from his part, he clarified that...
Now, why annex pictures? What are these?
These are the pictures to show, Your Lordship, that even now they have encroached into the paddy field and residential area of the people by virtue of this notification. And even police complaints has been filed against the villagers.
Yes, Dr. Mozika, you take.
My Lord, there are 2-3 aspects, my Lord. There are 2 petitions, my Lord. Lord says you pointed out there is no common cause of action for petitioner number 1 and 2. My Lord, petitioner number 2 it itself shows there is some kind of collision, my lord. So that apart, my lord, now, my lord, my
No,
lord.
it affects villages. See, such
My
a
lord,
huge
kindly
piece
see-
of land is bound to affect some, you know.
My lord, that's not correct. my lord.
One aspect is that if at least you can show that notices were issued to all the surrounding
My lord,
villages
I'll show that, my lord.
when the said registration was.
I'll show that, my lord. My lord, kindly see what is the prayer, my lord. They are challenging the certificate, my lord, land registration certificate, which has been passed by the chief forest officer, my lord. Now the rules, my lord, which are the governing rules as forest management and context of forest rules, there's a clear provision for filing an appeal against an order passed by CFO, my lord. Now, my lord, petitioner number 2 has already filed an appeal before the executive committee, my lord. Lords, kindly see, my lord. Page 56.
Yes.
Now the statutory remedy has been availed by petition number 2, my lord.
Why not answering it?
Yes, Your Lordship, they have not.
So we'll dispose it off. Let them dispose of the appeal.
My lord.
In the meanwhile, I have an application for stay of the impugn
My lord, and the
notification.
petitioner number 1, my lord, what they have done, they have filed a complaint before the CFO only for cancellation, my lord. My lord, lordship will find that. My lord, they cannot pursue parallel remedies. While they are pursuing remedy before the statutory authorities, my lord, they are filing a writ petition also, my lord. My lord, kindly see. Now, my lord, after this appeal has been filed before the executive committee, my lord, notice has been issued on 21st
March.
21st June, the date was fixed, my lord, for filing of so cause.
We have not received that, Your Lordship.
When you join this appeal. You give the appeal
Your Lordship,
number.
in the meanwhile, Your Lordship, because various laws have been violated, Your
My lord,
Lordship.
there's no question
And the
of mistake here.
application, Your Lordship, just give me 1 minute, Your Lordship.
Nobody is like this. Now, if there's statutory remedy where the executive committee vested the power
Your Lordship,
to appeal over the order of the
Your Lordship, with
CFO,
regard to
then
that,
you
Your
have to ask them for
Your
whatever
Lordship, with
orders.
regard to that, Your
We
Lordship,
can't at the same time pass orders here, at the same time allow the prisoners to go there. It's not,
Your
it
Lordship,
would not
with
violate.
regard to that, the petitioner number 2
Well,
has
kindly see
approached
the-
the executive committee, Your Lordship, through the secretary. The secretary verbally informed her to go to the court, Your Lordship, that they are not going to take any action.
Who's the secretary? He's a legal advisor.
Your Lordship, she's the through the secretary, Your Lordship. Your Lordship, kindly.
We'll pass directions.
My lord, the appeal has been filed
Your
on.
Lordship.
We'll pass directions.
My lord, the appeal has been filed on 11th of March, my lord, 2024. Two dates have been fixed, my lord.
Your Lordship, we have not received any of those notice.
Okay, you'll get notice. We'll start. You will rewind it.
In the meanwhile, Your Lordship, I pray for stay of the interim for the impugn notification, Your Lordship.
We rewind it from there. Then you start afresh.
Your Lordship, just give me a minute, Your Lordship. I just would like to point out one legal aspect to this, Your Lordship. Your Lordship, in the application form, it is clearly stated through the law, Your Lordship. And through RTI application, Your Lordship, we have found out that the recommendation that the registration was
We have
done.
a very good case.
The registration was done as per the recommendation made 45 years ago, Your Lordship. Well, the Act clearly states that it has to be the Deloitte, the present Deloitte who has to give.
Understood. Now you see, it's like this. Now when your appeal is
But
there.
we've not received those notices, Your Lordship.
They have filed appeal, my lord. There's no question of them not receiving appeal. It's their appeal.
We'll give observations. Don't worry about
Your
that.
Lordship, I pray that in the meanwhile, because villages are affected, Your Lordship, I've annexed those photographs.
We can't give anything else.
I've annexed those photographs,
My
Your
lord,
Lordship. They
any-
are being
my lord-
restrained from entering,
my lord,
Your
what they are
Lordship.
doing, my lord.
And even in the prayer, Your Lordship, I've prayed for state of the impugn notification, but no order has
My
been
lord, what
passed,
is
Your
happening in
Lordship.
the ground, my lord? The Krangsuri falls within this land, my lord.
This is not related to that at all, Your
My lord,
Lordship.
what they are doing, they are chasing out the tourists, my lord, from
This is not related to that, Your Lordship. That is the member of the Raj.
This is what they are doing,
This
my
is the village, Your Lordship.
Who are you?
Because I'm the respondent number 3, my lord. Because she's asking Your Lordship as in.
You're a Deloitte.
No, Your Lordship.
I'm the Right Buam, my lord. My lord has expressed that to maintain status quo. My lord, it seems my learned friend has suppressed some vital facts, my lord. The Dorbar Shnong, my lord, we have filed a suit against them, and this suit is pending. My learned friends appearing in that suit. For 3 months, they are not filing WS, my lord. And there's an interim injunction against them.
Your Lordship, because
number
that
one.
is, we are
Now,
agreed by the order of district council, Your Lordship.
they have suppressed this fact, my lord. And then secondly, my lord, so far as their claim that the villages falls under this registration, my lord, as per this map that's been prepared by district council, this villages has been excluded, my lord.
Your Lordship, they are
And
included,
in
Your
fact,
Lordship.
my lord, in fact, all this while they have been asking permission from us, whatever activities they have to carry out, whenever they want to expand the village, they have asked permission from us.
Doesn't matter. Like whatever is appeal pending, you will be heard. You file
Lordship, in the
whatever,
meanwhile, I pray that
requisite,
for interim, Your Lordship,
requisite.
because District Council is not hearing us, Your
No
Lordship,
status
at
quo, my
all.
lord, because the civil suit
And
is
they've
pending.
also admitted that they did not issue to notice
They have
to us,
suppressed this vital
Your
fact, my
Lordship.
lord, that civil
And
suit
the
is
map
pending.
clearly mentioned, Your Lordship, that we are under this, our village falls under this map, Your Lordship. It is at page number 36.
My lord, so far as our civil suit is concerned, we have clarified that in spite of receiving copy, in spite of participating in the suit, they are misleading this court, my lord.
Your Lordship, I did not mention about the title suit because I'm only aggrieved by the order of Executive Committee, Your Lordship.
Because this pertains to that land, and that land is, we have filed a civil suit, my lord. We
Because
have
the
brought on
moment they
record
got this
all the...
notification, Your Lordship, they filed civil suits and they filed police complaints against anyone who entered into the village.
And why are they
And on
suppressing
top of
this?
that, Your Lordship, they have created obstruction, Your Lordship.
No, my lord.
Even villagers
No, my lord.
cannot even enter their peripheral. I have annexed the photographs, Your Lordship. Even residential area they have entered.
My lord, I can place the civil suit, my lord. Everything will be clear. They are just misleading this court, my lord. In fact, they are filing appeal. Let them pursue the appeal. Why they are not pursuing the appeal also?
We have
got
not
the
get
notice
notice, but we
recently,
got
my
the
lord, and
appeal.
we've asked
Didn't
time for
file
filing
it.
show cause.
Anyway, it's all right, yes. Yes. Krang Suri isn't there.
No,
Yes,
Your,
my lord.
Your
Now-
Lordship.
now that is
Your
a
Lordship,
separate issue, my lord.
Your Lordship.
But it
Not
falls
regard-
under this
not
map,
with-
my
not
lord.
with regard to this
It falls
Madhipur
under this map, my
village at
lord.
all, Your Lordship.
In fact, before they filed this suit, this writ petition, my lord, we have filed FIR against this Rongbak Shnong, because he was leading a mob of 200 people to chase away tourists from Krang Suri. We have already filed an FIR against him, and this particular writ petition is motivated, my lord, just to cover up the wrongdoings. They are filing before this honourable court,
Your Lordship,
suppressing all the material facts, my
We
lord.
have filed the representation prior to this
They have not
Krangsuri issue,
disclosed-
Your Lordship.
They have not even disclosed the fact that FIR is being filed against them, civil suit is being filed against them.
Yes. Have you filed your power?
Yes, my lord. It's here, my lord. I filed it.
You file your power?
It's here, my lord. Just-
You filed it? Yes.
Yes, my lord.
Yes. Where is that Mosika regarding appeals?
The provision, my lord. Rule 7, my lord. It page 27.
Page
27, my lord.
See, one thing I normally will not create a situation where page.
Page 27 of this book, my lord.
Lordship, we are compelled to come
We
here
not
because they
yes,
are
we
not.
understand you compel, but then
They're
we'll
not
set
passing
the
any
things.
orders, Your Lordship.
We'll set the things in order. Okay. Yes. Because the registration was for under section 4. of
Section
the-
4B and C. For Lao Sumar, Your Lordship, it should be under section 4A.
That's
That
what
itself was done
Yes, speak
incorrectly.
down. Yes. You all have adequate opportunity. Okay. Yes. Heard MS PS Nongbri, that comes with the petitioner. Next, Dr. N. Mozika
For 1 and 2.
is present on behalf of respondents 1 and 2, and Mr. J. Shilla has filed his power on behalf of respondent number 3. Stop. As the issue in question is short, this matter is being disposed of at the motion stage itself. So, next paragraph. The complaint of the writ petitioners is that the respondent number 3,
Respondent.
this is Raj Buam, represented by Secretary. had, without notice to the petitioners 1 and 2, who are stated to be vitally interested, had applied for registration of forests as Lauri Sumar. Situated at Eleka Amwi before the Chief Forest Officer of the Jainte Hills Township Council, Juwai. It is further submitted that pursuant to this application, notices was only issued to the Doloi Eleka Amwi, bracket pro forma respondent number 4, the General Secretary of Raj Duam, and to the Assistant Forest Officer. Whereafter, without the knowledge of the petitioners, this registration was allowed for an area measuring, where is that? Measuring?
Measuring 5,000.
533 to measuring?
5,226.03.
It's 35.
Page
5226.
35. Measuring
5226.03 hectare.
measuring 5226.03 hectares stop. It has been contended by the learned counsel for the petitioners that the entire exercise was conducted behind their back, and further the said registration was made on the basis of a recommendation given by an erstwhile Doloi.
Your Lordship, this is at page number 67.
By erstwhile Doloi.
The type copy is page 68.
Erstwhile Doloi. Where's the type copy?
Type copy is
Doloi.
68, Your Lordship. The true copy.
Erstwhile Doloi made erstwhile Doloi on 12
October 1979.
12 October 1979, which he submits is in violation of section 15
Your Lordship,
of the
section 18, subsection 11.
of the Ashnong Act.
Yes, Your Lordship.
Section 18,
Subsection 11, Your Lordship.
18, subsection 11 of the Jainte Hills Autonomous District, bracket, installation of Eleka and village and election, comma, appointment, comma, powers, comma, functions and jurisdiction of Doloi, stroke Sardar and Ashnong Act 2015. He therefore submits that the grant of the registration being illegal and without due process, the same be set aside. The same be set aside?
Yes, Your Lordship.
Yes, and the matter be examined afresh. So,
That is also my prayer in the repetition, Your Lordship.
next, Dr. M. Mozika, learned, said teachers, learned senior counsel appearing for respondents number 1 and 2 has at the outset raised objections as to the joinder of the petitioners and submits that petitioner 1 and 2 have separate causes of action. It is further been pointed out that as per the rules framed under the rules framed under the United Khasi Jante Hills Autonomous District, then bracket Management and Control of Forest Act 1958. At Rule 7, it has been provided that any appeal against the order of the Chief Forest Officer shall lie to the Executive Committee. Stop. It is submitted by Learned Senior Counsel that the writ petition number 2, as is evident from annexure.
Page 56, annexure 9.
From annexure 9, annexed to the petition, that the petitioner number 2, I've seen evidence that. Yes, and the petition has already approached the Executive Committee against the registration of the forests of Right Buam, and that the same is under consideration with notices having been issued to interested parties. Stop. Therefore submits that at this stage no interference is called for, inasmuch as statutory remedy has already been being availed of by the petitioner number 2. Stop. It is further submitted that the respondent number 1, or the petitioner number 2, is further submitted that the petitioner number 1 also has been issued notice.
We have not received any other notice.
Okay.
We have received notice, my lord. Respondent number 3.
We'll record its submissions.
But the notice has been issued to CFO and Right Buam, my lord.
Not to us.
They'll be issued, my lord.
Yes. No.
They are the appellant, in fact.
No. That notice have been issued to the respondent number 3 and to the Chief Forest Officer, but no notice has been issued to the petitioner number 1. Stop.
1 and 2.
1
and 2.
2 is the appellant. So what notice we issued to her?
But then she's not been asked to appear, Your Lordship.
Yes. Anyway, then Mr. Jay Shala, who is present on behalf of respondent number 3, has raised strong objections to the prayers made in the petition, and submits that the matter with what do you say, that there's a
We have filed a civil suit against
and
They have
submits
filed,
that
Lordship, the moment they got the
there's a
notification.
civil suit pending between the petitioner number 1 and the respondent number 3.
In fact, we have also included Darbarshnong
No, we'll not say that. And
they have already compromised.
Stop. He further submits that the contention of the writ petitioner that the village is situated within Raj Buam is incorrect, as inasmuch as, then again as per the map issued by District Council, the villages have been excluded from the said registration. Stop. He therefore prays that the petition be dismissed. Correct?
Yes, ma'am.
As is creating as is has resulted in a multiplicity of litigation. Next paragraph. MSP Dombri in reply has rebutted the submissions made by the respondents, and submits that there has been disturbance to the cultivation of villages apart from other disruptions.
Residential construction.
Yes, disruptions. Stop. Next paragraph. Heard and counsel for the parties. It is noted that the Chief Forest Officer by the had registered the said forest on 8/12/2022. Is there a period of limitation prescribed for appeal? No.
No period is prescribed.
Your Lordship, after objection, it should be
30 days is there under rule. There is the other rule.
Three months, Your Lordship. 3 months after filing objection, it should be disposed of. But in my case, it was not disposed of.
No. It does, but
My lord,
appeal. For
my lord, page 42, Your Lordship kindly says, my lord, of the book.
Of the petition?
Of the book, my lord. Rule 75 says that any party agreed with the order of the Chief Forest Officer.
42?
Page 42, Rule 75, my lord. Left and bottom.
Yes.
30 days.
But they never received such order, and it doesn't matter.
Well, delay may be controlled, no problem.
No. And when did you come to learn about it?
We came to learn in the month of November last year, Your Lordship, 2023.
And that.
And after that, they filed a suit against us and police complaints.
Knowledge about registration came to be known to them only in December.
November for petitioner number 1 and December for petitioner number 2.
23, not November, December 2023, for which representations and other objections had then been filed. Stop. It is further noted and as submitted by the counsel for the district council that any order of the Chief Forest Officer is appealable under the rules before the executive committee. Stop. Where's that petition? 56?
56 minutes, appeal.
And 56. And from materials on record, it is seen that the petitioner number 2 has filed an objection which can be treated as an appeal on 11 March 2024. Stop. In this view of the matter, as the same is yet to be decided, and notwithstanding the fact that the petition number 1 is not party thereto, it is hereby directed as follows. Yes. As follows. Right. 1. The objection to the registration of the forest of Right Buam filed by the petitioner number 2 before the executive committee shall be taken up and registered as a regular appeal against the registration dated that is
2022, Your Lordship.
12.
I apologize, Lordship. 8/12/2022.
8/12/2022. Stop. 2. The respondent 1 and 2 in this regard shall issue notices to should be the surrounding villages.
Yes, Your Lordship, because surrounding villages are also affected.
My lord, in fact, if I may just point out, my lord, page 53, Your Lordship kindly sees, my lord.
Who are the affected people?
Page 53, there are 4 villages they are claiming to be affected, my lord.
Yes.
Page 53.
Whoever's interested, let them be heard. It's what, Anthony?
Your Lordship, I mean, I just...
To the headman of Thangbuli.
My lord, so far as Thangbuli is concerned, he's already withdrawn this. Because after we file a suit
It's very good. If they withdrawn, very good. They will be party, then they will see the withdrawn.
Okay, my lord.
Then we don't want anyone coming later on that we didn't receive notice.
Yes, my lord.
Yes.
Your Lordship, I may just interrupt. Your Lordship, I may also be allowed to file petition number 1. May also be allowed to file a fresh appeal.
Just relax. Yes. Let the order be passed. Yes. To other concerned villages, namely headman of Thangbuli village, Latkhur.
The petition number 1, my lord, Latkhur.
Latkhur, bracket petition number 1. Headman Shkin Talang, SKSHAN Talang, and headman of Jarang village. So to enable them to participate in the proceeding. Number 3, the petition number 1 is also permitted to. You want to file a cross
appeal.
You want to file
bring some more records.
Yes,
I just wanted to point out, my lord,
place in the materials. Yes.
What petition number 1 is done, my lord. He has filed a complaint to CFO itself, my lord. Page 53, my lord. So that can be transferred, my lord.
That order has not been passed by that.
No, then it can be transferred. That's right.
Because otherwise
the petition number 1 is at liberty also to place any further materials as considered necessary before the executive committee for its consideration, and as submitted, and as a complaint against situations already pending before the CFO filed petition number 1, the same shall be taken up by the executive committee. Then number 4, the appeal thereafter shall be taken up after notices are complete and pleadings filed and pleadings other materials filed shall be how much time?
6 months, Your Lordship.
Shall be taken up and disposed of within a period of 6 months from
preferably within
Lordship, they will keep
15
on
days.
delay, no.
Preferably within a period of 6
Because my
months.
appeal was since March till June, Your Lordship.
Preferably within a period of 6 months from the receipt of the order. Number 5. As apprehensions have been raised with regard to the possibility of disruptions being caused in the area by the parties in their own capacities. So it is directed that the respondent number 1 and 2 shall, in a time being, ensure that there is no such situation arises until the matter is decided by it. Yes. No disturbance.
From our side,
some direction to petitioners also to maintain peace and harmony.
The parties here.
My lord, if I
Your
just
Lordship,
may,
I pray that
if I just
interim
may
stay
submit,
may be given, Your Lordship.
Yes. No, my lord. If I may just submit, my lord. Now, what is happened in the ground realities, my lord? Now, their village, Mlatkhur village, a mob of around 200 to 300 people.
That is not before the court.
No, my lord. What I'm saying is that they will misinterpret this order, my lord, and I will say that because of this order, we don't have authority anymore over that land at Krangsuri because we are running that land right now. Tourists are coming. They are stealing.
Your Lordship, with regard to Krangsuri, it's between the members of the Raj, Your Lordship, not the village.
Order, they'll misinterpret this order.
Number 5,
The sole intention is that of approaching this court, my lord.
Disturbance being caused by the petition number 1 in the area. Stop. It is further provided that the parties shall not cause any disruption or disturbance in the area, and the respondent 1 and 2 shall ensure that no party in their own capacities causes any. Should we write terrorists? We shouldn't write that.
Your Lordship, what about the respondent number 3, Your Lordship? He's also causing destruction, and we are not even allowed.
Parties? That's all, yes. Matter only stands disposed of, yes. Why is very lucrative?
Your Lordship, the ground reality is very dire, Your Lordship. It's very, very dire.
Because
No, my lord, because
Your
this...
Lordship, he is clubbing Krangsuri, which is not at all a subject matter of this writ petition. No, Your Lordship, it is not.
Yes.
Item number 6.
If it is Lordship. Lordship, this is the misapplication filing for restoration of the petition WPC 103 of 2017. Your Lordship, that petition is actually, the petition has been filed challenging the order of the EM and the CM of GHADC. However, Your Lordship, the petitioner had been diligently and proactively pursuing the matter. Lordship, this is because they have dismissed the writ petition 103 of 2017.
Who dismissed it?
By the learned secret bench during the pandemic, Your Lordship. So there was some delay of 400.
During pandemic?
Yes, in the year of COVID-19 time.
Is this was a default?
Yes, Lordship.
Where the order?
The order I have enclosed is, Lordship. It is there. Page 13. Yes, Lordship. Annexure 1.
Then you file again after that, what happened?
After that, there was some defect in the petition.
Why are you trying to restore something which is not alive anymore? You file a subsequent petition. Correct. What was the order we saw just now? What was the order dated 12/4/24?
This is the application which I have filed, but there was a defect in my petition, so I have...
No, what is this?
So I have withdrawn. Lordship.
It's for restoration?
Yes, for restoration. For restoration. Earlier also is for restoration only, but there was a defect in my petition, so I have withdrawn, Your Lordship. Then there was a liberty was given.
In this matter, notice has to go. There is a delay of filing this application, my lord, for restoring the matter. There is a delay of 899 days, my lord. So notice has to go to the private respondent first.
No, Lordship, the delay actually is after excluding, there is a Supreme Court judgment that there is which excludes 715 days. Excluding that, we have only 491 days, Lordship. And on top of that, we are supposed to file within the period of 30 days. 30 days plus 317 days. The delay.
Where is the delay being computed here?
Yes, Lordship, that there is a.
Where is the application for condemnation?
May I take the.
Where's the application for condemnation then?
Application, I have filed 2 petition, Lordship, actually.
Where's the other petition?
The other one? We have filed it together, actually. Maybe they are not listing. We have. This is condemnation and then
where?
2 application, 2 separate application actually I have filed it.
Where the computation of delay?
If my lord may kindly take up miss case number 108.
108, okay.
This is an application for condoning 899 days, my lord.
Okay. Oh, this is the one.
Yes, this is the one, my lord. For this notice has to go.
There must be some red notice issue. Stop to the respondents number 1,
5, and
no, 5 is here.
6. No.
Only 1.
6. Yes.
Only 1. Yes. State is for 6. You serve notice on state. Heard Mr. P. Sangma issued stop this application of condemnation of delay of 899 days for restoration of WPC number
103.
103 of 2017, which was dismissed.
Respondent number 3, my lord, has to be struck down.
On 1/2/2021. Yes.
Respondent number 3 has to be struck down, my lord.
Yes. How do you make parties? You're doing case against the council all the time. You make parties properly. There's a basic pleadings, you know. Mr. SD accept notice on behalf of
4 and 5
and points out that respondent number 3 be struck off as what to say? Why do you make them a party? Who wrote this? Who wrote this petition?
There is I apologize. There is a
you don't need to apologize to me. Apologize to yourself. That's all. But annoy the court also. You just write anything. Garu Hill, Solicitor Council. Go and serve it then. without service to Garo Hills, then there's no person accepted. We won't take up a petition if that's the case.
Actually, there are 4 and 5.
Right, State of Meghalaya, just write one like CM respondent. Tom, no? Number 4 and 5. It's top of, yes. That's it. Refers to Garo Hills Residential Council. Stop. Next one. Who will accept notice of state? 2 and 6. Is MSNG Chilla as well as acceptance on behalf of 2 and 6. Notice to be issued to respondent number 1. Stop. As submitted, respondent number 3 stuck off just after 3 weeks for service report objections.
Item number 7.
Here, filed a this application because to the secretary to the government Meghalaya personal department, my lord, because in their affidavit they have stated that there is a state department has stated that
yes. Impleading.
Yes.
Yes. Any objection?
No objection, Lordship.
There's an application for impleading the secretary to government of Meghalaya personnel and AR bracket B department as respondent number 5 in WPC number 322 of 2023. Stop. MSNG Shalla say account advocate does not have the objection as the party is necessary. Accordingly, the Secretary of the Government of Meghalaya Personal ARB Department is impleaded as respondent number 5. In this case, allowed and disposed of. In the main case, in with order passed in this case number 109, so and so, the secretary, so and so, in view of order so and so, registry directed to add the secretary so and so as number 5 in the course title. Based on 5th, what?
Next month.
5th 7, 2024, yes.
Daily list, item number 1.
Yes.
The suspension has not been reviewed beyond 90 days.
Yes.
Supposed to.
Why do we? What's it for today?
Today, my lord, last occasion my submission was. Yes, my lord. Last occasion submission, my lord, on 28th March, within 90 days, a committee was constituted, my lord, and they seized upon the matter.
What's the recommendation of the?
Yes, your lordship, I have got it. I have got it, my lord. My lord, I'm just. The original is here, my lord. This is the Xerox copy I am giving. If your lordship want to see, original is also under the seal. Your lordship will kindly see in the next page the recommendation.
This is 6 May.
3rd May, 24.
3rd May, 4 May.
3rd May. Sorry.
Lordship, my submission will be, there's only a recommendation. Like, Lordship, kindly come to Rule 6 again.
We can't split hairs, Mr. Nompure.
Lordship, kindly come to the rules, Your Lordship. The rules are very clear, Lordship. 10.6. I've annexed in my repetition, page 33, Lordship.
You mean an order has to be passed?
An order has to be passed, Lordship. Under Rule 6, Lordship.
Page?
Page 33, sir. Page 33. Yes. The last page of the repetition.
Yes.
Lordship, Rule 6, Lordship. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension on the recommendation of the review committee constituted for the purpose and pass orders either extending or revoking the suspension. The rules clearly mandates, Lordship, there should be an order from the competent authority. Now this is only a recommendation, Lordship. Now further, Lordship, Rule 7, Lordship. An order of suspension made or deemed to have been made under sub-rule 1 or 2 shall not be valid after a period of 90 days unless it is extended after review for the period before the expiry of 90 days. Lordship, the recommendation is on 4/5/2024.
So we'll give you notional reinstatement From which date? From up to 6 May then.
Lordship,
90 days expired when?
From the date of suspension, Your Lordship.
Yes,
The date
when,
90
when,
days.
yes, when
on
it
18/1,
expired?
Your Lordship.
18/1.
18/1/2024.
Okay, 18/1, then review committee you're supposed to sit within. By 18/1 has to what?
Before 18/1, the review
but you
committee.
communicated your release.
I communicated on
when?
18/1, Your Lordship.
18/1, okay. So from
Now, from that date, Your Lordship, the 90 days period will expire on 17/4, Your Lordship. Now, kindly see the recommendation which has been placed before, Your Lordship. That recommendation is 4/5.
So 17/4 is the recommendation, or is the 90 days from 18/1?
90 days, Lordship.
Okay, 17/4, and the recommendation for your further suspension is on
4/5.
On
4/5.
4th of May.
4/5/2024.
So 17/4. 17/4 to
4/5.
to 4/5. They give notional reinstatement for those days.
Lordship, there is no order also, Lordship, for further
Lordship,
revoking or modifying the suspension order, Lordship.
Notional reinstatement from 17/4 to 4/5, and the suspension is renewed again after 4/5 after review.
No, my lord, here if I can point out what my London friend is saying, he was in custody, police custody. You know, the rules very categorically say in case of deemed suspension, well, the period of 90 days will start, my lord, when his release come to the knowledge of the employer. So admittedly, my lord, 18/1, he submitted a copy of the bail application. So it starts running from there, your lordships. Now in 28 March, well within 90 days, we constituted a committee. They were seized upon the matter.
But you didn't pass any orders on.
They were seized upon the matter, your lordship.
Lordship,
They passed
till
this
date there's
order.
no order, Lordship.
No order. We cannot pass
Till
an
date
order
there's
because
no
matter
order.
is sub judice. Matter is sub judice.
That is only a recommendation, Lordship.
Well, formal order we cannot issue because the matter is sub
A
judice.
formal order has to be passed by competent authority under 10/6,
Okay.
Lordship.
We'll hear this better next week. You bring authorities on interpretation.
Lordship, I have authorities right now.
Yes. The records have been produced showing that the review committee that we constituted on 28th of March 2024 to review the suspension order had met, and by recommendation that the 3/5/2024 had reviewed the suspension order of the petitioner and recommended the suspension be continued pending inquiry in university. Stop. And Mr. Emran Nongpur submits that the order dated, the review order dated 3/5/2024 is outside the 90-day period. And accordingly, the writ petitioner should have been reinstated before the said date. Stop. As he has, the rules has also been placed to substantiate submissions. As the matter requires some interpretation and hearing, listed up to 1 week. Yes, for admission hearing. Yes.
Ashubha,
Item
more
2.
than 7 months.
Sorry, we're a bit pressed with short of staff. Yes.
Item number 2.
I'd have taken up right now.
My lord said, in item 2 and 3, my lord said directed a filing of the affidavit. We have filed an affidavit, my lords, in both the matters.
Yes, now it's been filed.
My lord, this morning I have filed. I have given the copy yesterday, my lord, to senior, my lord.
Okay, have it day after tomorrow. Yes, after it's just been filed and just been brought on record, it's a matter day after tomorrow.
There's only one issue that I must point out.
I'll examine it.
No, Millet, I must point out at this stage that the lordships had issued notice on that limited issue. Now, what has come on this affidavit is I've examined it, Millets. Besides, Millets, the stereotype answers that are usually there from MECL, with all due respect to them, the core issue, Millets, does not seem to be answered here, and they have craved leave of your lordships to file a detailed affidavit. So I'll again be faced with that situation, Millets, that
You know, the petition is not maintainable. Objections regarding maintainability have been taken.
Yes.
Oblige, Lord.
3 and 4, same Millets. 2 and
3 and 4 plus 3 plus.
4?
2 and 3.
Day after tomorrow, Millets.
Do we have instruction? We don't have instruction. Give me that order, please. Give me that order. Where's that order? Amit, this is your lordship. Lordship, there is an order dated 25/4/24, your lordship, which requires that the state government will cooperate. Your lordship, we are awaiting instruction in the matter. If I
From whom?
from the state government, Your Lordship.
How many connected petitions are here?
Item number 4 to 14.
4 to 14, then 36 to 38, Your Lordship.
36.
Mr. Andy Shula, how long will take instructions? Pursuant to Order Date 25/4/2024, wherein certain directions had been issued with regard to the views and comments with government, which were required. Pursuant to Order Date 25/4/2024. Well, yes, Dr. Mozika.
In fact, after receiving the report from the DSA, the Joint Secretary Government of India had held a video conference with the state government, seeking their views on the report.
Yeah, what no instructions?
No, Your Lordship. I'm awaiting instruction, Your Lordship. Lordship, kindly have all this matter after 3 weeks, Your Lordship.
Yes, Mr. Shulai submits the bar that pursuant to inquiry which had been conducted by the PSF, he has not been instructed as what transpired in the meeting with the state government and the said authorities. And the Mr. Shulai is, yes, Mr. Andy Shulai submits that he has no instructions as yet on any developments after
3 weeks, Your Lordship.
Yes,
apply, Your Lordship.
Deeply applies, Your Lordship.
4 to 14, 36, 38, Your Lordship. 36 to 38. Apply, Your Lordship.
Must proceed.
Evidence is, you have not filed the evidence.
Well, the affidavit is ready. We're in the process of filing it, but some defects.
It's for adducing evidence today.
My lords.
Then?
Well, we're in the process of filing the affidavit, but some defects have crept into the affidavit. That is one difficulty, my lords.
Why do you wait the last moment? Because today we fixed for commencing at 2 o'clock for evidence.
Well, let's have it. Just give us a day's time, my lords. We'll ensure it is filed by tomorrow morning. Because I'll have to serve an advance copy.
Then they have to cross on that evidence affidavit. Then you have to give them adequate opportunity.
Would it be convenient to your lordships, my lords, if we have it next week? Then I'll ensure that it is served to them tomorrow.
Then you write an application.
We'll file a formal application.
Then we have to refix the date for evidence.
16.
Just file a formal application.
One thing, Mr. Paul, is he still interested in this?
This matter, my lords, is interested. Because
but the way our things are going is just that, he's just...
Well, lords, here he was a little tied up with these elections, my lords. That's why earlier we had to seek time. What, my lords, why this, I must be candid before your lordships, why, my lords, we are having to seek additional time is because certain documents, my lords, on the basis of which your lordships would have to decide that matter, I'd have to exhibit it as a, my lords.
You have to exhibit, yes. You have to be next to the evidence.
That is the only reason why, my lords, the defects are
just kicking the ball around for fun.
No, my lords, he's interested. As a matter of fact, this would have some light, even in the other matter, my lords, where your lordships are aware that there's a fresh challenge also. Similar issues. On the same, my lords, opening of the EVM and what is the procedure to be followed by the Election Commission.
Only one prayer, your lordship. If it is refixed, let it be next month, 24 or 25. If it is refixed. One prayer, your lordship.
24th of July?
Yes, your lordship.
Yes, Mr. Paul. Mr. Paul won't object because he's...
No, I will not
because we have so many program in me.
Program in?
We have so many cases.
Okay,
in other
24th, 25th, 26th, minutes, subject to your lordship's convenience.
Yes.
So pass order as well.
We file a formal application. We'll file a formal application.
Yes.
Right.
16.
Please, Lordship. Lordship, this matter we're supposed to file our affidavit, Lordship. And yesterday, Lordship, we received one affidavit from the respondents, Lordship.
Which respondent?
Lordship, yesterday we received this
from?
So respondent number 4, Lordship, was filed last.
Where's Kibi Brasali then?
Therefore, Lordship, I'm praying for some accommodation, Lordship.
For filing rejoinder?
Rejoinder, Lordship.
Yes, of course. Mr. Tidakar PS was allowed 2 weeks time to file a requisite rejoinders.
Obliged. Deeply obliged.
17.
Yes, Mr. Panthi, his file affidavit or not?
I filed my lord on the last occasion.
Rejoinders
Your Lordship,
have been
I
filed.
may be allowed to file a rejoinder affidavit.
You've already been allowed. You have not filed it.
I pray for the time, Your Lordship.
How much time?
2 weeks, sir.
5 weeks.
2 weeks, Your Lordship.
There's 2 weeks further time allowed for rejoinder. Just thereafter.
18.
Please, Lordship. Lordship, the respondents are yet to file the affidavits also.
You filed 124?
But number 5, I am praying for some more time.
124 file. 5 why? Yes, that's recorded, yes. Why the delay?
But I'll file it. I have received the instructions.
Yes, Dr. Mozika said praise they allowed further 2 weeks time for affidavit praise allowed. We allow just because the parties are far away.
19.
My lord, a state is yet to file affidavit here, my lord. I'm praying for some more time, my lord.
What about 6? I won't file.
I pray 1 more week.
1 more week. You also 1 more week.
My lord, I pray for 2 weeks, my lord.
Response allowed for affidavit.
20.
Yes.
The respondent is yet to file the affidavit.
My lord, it was only on the last occasion, my lord, we were
Yes.
given the liberty to file the affidavit. All this while we're waiting. So, my lord, I'm praying for further time, my lord. We're waiting for instruction.
Yes.
Lordship, I'm
6 to
similar
10. You already filed.
Similar prayer, Lordship. I'm praying for some more.
2 weeks for a time to respond file affidavit as prayed. 2 weeks for a time allowed as prayed.
21.
My lord, this is a contempt matter, and I got a specific instruction, my lord, that in 2 dates, my lord, there was an inquiry in the plot of land for demarcation, my lord. Then after the inquiry, this is the inquiry report, my lord. It's written in Garo. I have a translate copy also. They was asked to appear, my lord. But as per the comment, my lord, if I am permitted to read, my lord, they are saying, my lord, upon receipt of the above inquiry report, both the parties were summoned by the deputy CEM in charge, Land and Revenue, Tura, and the parties appeared in this court. However, both the parties failed to appear in the court of so-and-so, Tura, on subsequent dates. Though the case was ripped for dismissal on default of the petitioner to attend the court, yet the deputy CEM in charge, Land and Revenue, Tura, was pleased to summon both the parties. So, my lord, let them appear, my lord, both the parties, my
They have
lord.
been appearing, my lord, but they have not been complying, my lord. I have got a certified copy to that effect, my lord. I'll just place it before the on the court.
See, the thing is that in contempt, we can't go and pass any orders.
Lordship,
It's just that
they have been
total contempt order. Who's in contempt?
They have been complying, my lord.
Both
Time and
parties
again, they have been called, my lord. Several times they have been appearing. The type copy is at next page, my lord. They're just to demarcate the land, my lord. They're not demarcating. They're just calling us every now and then, my lord. They've been appearing.
Yes.
This is a certified copy, my lord. On the last occasion, my lord, on 6th itself, they were called.
No, 26 July then.
Again, they have been called on 26 July,
Yes,
my lord.
a third copy of the orders fixing demarcation on 26 July is produced by the petitioner. This is the matter on 29 July.
My lord. We are processing, my lord. It's not that we are sitting tight.
Do it, my lord.
I know
it's difficult in summertime, but even then.
22.
I was just there the other day. Yes, Mr. Nandi.
My lord.
Have you filed affidavit?
It
is, I can file it, my lord. I may be given 2 weeks' time. I will file my affidavit.
Your Lordship, if required, we will file our rejoinder.
If required?
Yes, Your Lordship.
But an interim order operating against Mr. Nandi's client?
Yes, my lord. Stays.
How long will you take, Mr. Nandi?
2 weeks' time may be
2
given
weeks.
before.
3 weeks' time?
Let it.
Yes, Mr. Nandi appearing for the sole respondent, correct?
Yes, sole respondent.
Response allowed 3 weeks' time to file affidavit. No, why should you file affidavits? It's CRP, sorry.
Actually, CRP,
But
my
yes,
lord,
sorry,
it is
I didn't
on
see,
the.
I thought it was read. Yes, what instructions do you have?
My lord, this very, if this
I was thinking is that
petition is gone through, my lord, the revision petition, the very ground number 1 and 2 itself says that the very petition by which they have filed to frame the preliminary issue, that petition itself is not maintainable because they themselves have stated that it is a question of fact and law. If it is a question of facts and law, in that case it cannot be treated as a preliminary issue. The point of limitation. It is their own ground. They themselves have stated.
Lordship.
Are you ready with the matter?
No, Your Lordship.
Then where's Mr. Hassan?
He is out of station, Your Lordship. So I humbly pray for time, Your Lordship.
Then you say that, or we'll pass orders.
Sorry, Lordship.
Yes. You should. What to do is. But because the proceedings have been stayed, correct?
That is.
Okay. When will Mr. Hassan be? When can you come?
Next week, Your Lordship.
Next week?
My lord, next week, if a date may be fixed, because on 2, 4th and 10th July, I'll be out of station.
Doesn't matter, just take a date from Court Master.
If
the A. Nandi Council for the sole respondent has submitted. Sorry, your name?
E. Ahmed, Your Lordship.
Mr. E. Ahmed, Learned Counsel for the petitioner, Vice Mr. S. Hassan, raised that the matter be taken next date due to the absence of arguing counsel. Mr. A. Nandi for the sole counter objection. Just the matter on. We take the date.
Your Lordship, interim order may continue.
Interim order may continue next date. Yes.
And Your Lordship.
Deeply obliged.
23.
Records are necessary.
My lord. Yes.
Records are necessary.
Record are not necessary, my lord.
Lordship, I've already
taken steps.
Yes, Your Lordship.
Yes, received. When was that received?
I'm not aware, Lordship. I haven't applied for the status report.
7/6. Office note indicates that the sole response has been served on 7/6/2024, but no appearance is made on her behalf. Next, in the interest of justice, this matter after. Give her 2 weeks' time to appear. 2 weeks for appearance of the sole respondent. Yes.
I'll apply.
24.
Please, Lordship. Here, so I have filed a miscase to impede the Secretary of Government Meghalaya personnel and the ARB Department Shillong because the state respondent they have filed the affidavit there saying that my regularization
1 second.
is yes.
Where's the state? Oh, you're there. No objection.
My lord, if my lord have page 9 of my counter.
Counter?
So it's already been of our affidavit, my lord.
But he's praying for
Page 9.
impleadment.
My lord, I just wanted to show that it's already under consideration. So not much.
Use will be, there'll be no use in impleading him.
That's right, my lord. If page 9
Yes,
and
what
10
is
of
other examination?
Yes, then the later matter may be considered, then their effective order may be passed. They're saying that it is under consideration on the last occasion because they said that.
Yes, okay. That's the main case, huh? writ petitioners before this court hear a prayer for directions to the state respondents to afford pension and other retirement benefits to the petitioner who serving for how long, you said?
32 years.
Who has been stated, who is submitted, has served for a period of 31 years under the respondent number?
Under the respondent number 2.
Respondent number 2.
Yes. 2, 3 and 4.
Stop. Next paragraph. The affidavit of the respondent number 2 indicates that the proposal for organization of the ad hoc service of the Directorate of Agriculture is under examination, of which, what's your name?
My Namsing Sheikh Marab.
Of which the name of the petitioner appears at serial number 9
Lordship.
of the list appended thereto. Stop. It is noted that this letter has been issued as far back as on 11th October 2023 by the Under Secretary of the Government of Meghalaya, Personnel and Observer Firms, B Department. Next, by interview of the matter, it is expected that a consideration for organization with such ad hoc companies should be completed. Should be completed within when? Period of?
In 3 months, my lord, I pray. 3
4
months.
months.
Lordship.
They can decide either way. It doesn't mean that once you give that deal will be regularized. No. Regularization of the should preferably be completed within 3 months from the date a copy of the orders presented before the said respondent. Stop. The matter of stands disposed of. Then in the missed case, with the order passed also, missed case also disposed of. Yes.
25. 25.
Please, Lordship, here the affidavit is yet to be filed from the respondent
Aye.
number 1 to 4, Lordship. Respondent 5 has filed, Lordship.
5 is 4?
I'm from number 4, Your Lordship.
You're not filing?
I need some time, Your Lordship, to file.
Why? How much time?
3 weeks
You
time,
haven't
Your
filed?
Lordship. I will be filing, Your Lordship.
Mr. Sulsun doing the for 1 to 3?
1 to 3, Your Lordship.
And MS for 4. Pray for unallowed further 2 weeks time to file affidavit. Stop the affidavit number 5. That's already been recorded last order, yes. Yes.
26.
My lord, I have already filed an affidavit to bring on to court for the service of respondent.
Where's the affidavit? Where's the affidavit? Just filed today?
Yes.
An affidavit indicating service upon the respondent number 4 has been filed today and the same is taken on record. Stop. However, none appears on there on. However, no appearance has yet been made on behalf of the respondent number 4.
May I please, Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to file the affidavit.
MSN Rajiv 1 to 3 prays for further 2 weeks' time to file affidavit. This matter after 2 weeks for after 1 to 3 for appearance of respondent number 4.
Much better, Your Lordship.
27.
Respondents are yet to file their affidavit.
My lord, I appear for 1 and
Yes,
2.
the
my
orders
lord.
are already
So
recorded
it's
there.
Medical College,
Yes.
my lord.
Prayer
What
for
else?
2 weeks' time, Your Lordship.
Why?
We are yet to receive any instruction, Your Lordship.
MS Salam for 45 praise funds allowed. Whether
2 weeks.
it's time to file
My lord,
affidavit.
if I may be allowed, because there's a small prayer with regard to salary, my lord, suspension allowance. So we have instruction to that we have already released to this college.
You want to file
So
an affidavit?
a small affidavit on that, my
MSR,
lord.
next, MSR only submits that though they are not, they have a limited role. However, they may be permitted to file a short affidavit indicating the
Suspension allowance, my lord, that have been released to a college.
indicating the not indicating, but file a short affidavit to bring on record the fact that substance allowance has been
A release to college, my lord,
has
for
been
the
released to
petitioners.
or the petition has been released to the college staff just after
2 weeks, my lord.
2 weeks.
Let the interim order.
Interim orders pass and they shall continue till next day.
28.
May it please, Your Lordship. Your Lordship, I'm praying for time on behalf of Ms. Zeti Longkandri for the state, Your Lordship.
What's happened to the country?
She's not well, Your Lordship. Respondent 125, Your Lordship.
Your Lordship, delivery status reports provided, Lordship, for the private respondent number 6, 7, and 8.
Yes. Officer indicates that notice not complete in 6, 7, and 8. Next paragraph, Mr. MS so-and-so, vice praised that how much time?
2 weeks, Your
For a
Lordship.
time of affidavit, yes, for 2 weeks for affidavit for service report on the private respondent 6, 7, and 8. Yes.
Supplementary list, item number 8, hearing.
Yes, Mr. Zarman.
Yes, with the record, Your Lordship. With the record.
Why we need the records for?
Lordship, the court of inquiry proceedings were called for this court to
Why?
ascertain whether the show cause notice was issued on the basis of that marriage certificate, because this is a case of plural marriage, Your Lordship.
Just look at that, just flagged it. Or you flagged that relevant part.
They have not supplied to the petitioner the findings.
So let them flag the relevant part. I expect the court to go through the records. You have not gone through them also. You have not gone through the records with them, man. At least you should assist the court to that extent.
With the show cause notice. Yes.
I've seen this. Findings.
This is show cause, no? So this is the show cause.
Findings and opinion of the proceedings.
Yeah. Yes.
Flag it.
This one, then another. You can go through.
What are you doing, Mr. Devnan?
If you're saying this way, then I'm saying to him. Yes.
No, I'm saying we flag the relevant part, the court will see. I know. Done.
Next page.
This too will be sufficient.
Thank you very much. Seen that? There's no pure then.
Lordship, only my limited cases, at the time when the show cause notice was issued, there was no marriage, Lordship, because the marriage was already dissolved by a competent court. That was only my limited.
There's a factum of you conducting the findings of the court at the point of time is that even as per your own deposition.
Depositions, Lordship. I've seen my deposition. Now, Lordship, that factum of marriage, why I got married to this lady also was brought to the knowledge of the inquiry officer.
Is that believable?
Lordship, and the knowledge as to why I filed a divorce also, that was also brought to the knowledge of the Court of Inquiry Proceedings.
Is it possible that you were duped by ladies signing blank document which turned out to be marriage certificate?
Lordship, rightly or wrongly, whether marriage, Lordship, kindly see on question number 9, Lordship, of the questionnaire, Lordship.
Of the deposition?
Yes, Lordship. That will be serial number 48, Lordship. Serial number 48, question number 9.
This is the fact they contracted plural marriage, right or wrong?
Lordship, they inquired what is the present status of your divorce. And I said we had already.
48.
Lordship, in the questionnaire in my depositions. It's part of the.
Yes.
Serial number 48, Your Lordship, the question number 9. What is the present status of a plea for divorce? Smriti Indira Gandhi did not attend any hearing of the same. I went to her a compromise by paying 60,000 and giving my motorcycle, and now we have filed for mutual divorce. So my contention is that, Your Lordship, now the impugned show cause notice which I have challenged before in this repetition, Your Lordship. The impugned show cause notice, at that time, relevant point of time, the marriage was not subsisting, Lordship. Because there's already a decree by the competent court. Now the show cause notice is at page 43, Lordship.
See, the thing is that if you're discharged without proper inquiry, understandable.
Lordship.
But it was after a thorough inquiry. That's why you wanted the court of inquiry proceedings. Then also thorough inquiry.
Lordship.
And then you've not been able to show anything. Your marriage subsisting at that point of time.
But I've shown my bona fides, Lordship, because the marriage.
Can
Lordship,
we condone that? Can
Lordship,
we condone? It's supposed to belong to discipline force.
I understand, Lordship. I understand the plight of the petitioner, Lordship. But only my question, my only limited submission will be like, Lordship, the dismissal is harshly.
Quantum.
Very harsh, Lordship. The quantum is, Lordship.
Why?
It disproportionate, Lordship, to the offence committed by me.
Yes, what you wanted to show for page 43?
Page 43, Lordship.
What do you want to show just now?
This is a show cause notice, Lordship, issued to me. Now they've issued this on 16 September 2017. Now
Yes.
on this day, Lordship, the second marriage was not in subsistence.
But the fact that contracted second marriage been admitted by you, will not that constitute an offence under the Assam Rifle Rules Act and rules?
Lordship, in the facts and circumstances of the case, Lordship,
Court is not sitting to appeal over the dispute proceedings.
Lordship.
We're not sitting, we're not to not overturn the findings.
Lordship.
We are just sitting here to see whether it's illegality, whether you've been afforded an adequate opportunity, whether rule of natural justice have been followed. Everything's in order. That's why we cast court inquiry. You have deposed very nicely and fairly. You have admitted. You've been advised also to file a case of fraud and cheating against a DD, which you have not done. So what remains?
My contention, Lordship, we quite understand, Lordship. My contention is that at a time of
findings.
Lordship, only that limited submission will be like, Lordship, the dismissal from service is quite harsh, Lordship. They can impose me other minor punishments, Lordship, but dismissal from service is quite harsh, Lordship.
Yes, Mr. Nirma, what do you have to say?
So you say whatever order is passed, it is justified. That's
a submission. Whatever order may be passed.
No, this what's order passed by the authority, it is justified because as per rule.
Yes. We're not sitting appeal.
Another submission, Your Lordship, there's no cause of action for issuance of the show cause notice, which at page 43. There's no cause of action for issuance of show cause notice.
You're not married at the point of time. But the fact that you went through the inquiry and you should have raised those grounds that I'm not married anymore.
Lordship, that's why
But that will not be up for consideration. Yes, subsisting. The thing is that where's the rules? Doing subsistence, like the first marriage, you contracted the second marriage, which is
what should the rules?
Suppose you're acquitted of a burglary case. Yeah, same thing. I committed burglary, but now I've been acquitted, so you know.
It's annexed to the repetition, the rules.
Let's see, where is it?
Page 54.
You tried very hard, but.
Page 54, Lordship. Now the petitioner is still staying with his first wife, Lordship, and he's out of job.
Okay.
And
he's a martial arts. He's a mixed martial artist. I saw. So he can good job as instructor anyway. Yes.
Page 54, Lordship.
Yes.
Sub rule 2, Lordship, of rule 10.
Yes. Then during the lifetime he contracted. It doesn't say he contracted, but if divorce, he'll be absolved. Does it say anywhere?
That is only my limited ground that I'm standing, Lordship. At the time when the show cause notice was issued, there was no marriage, Lordship, in such
Yes,
instance.
okay. Take down and might as well dispose of here. Hearing साथ क्या है?
Slightly.
Huh? In those first appeals, what is you have to reply, correct? How long will it take?
If Lordship give me 2 days.
2 days?
I'll finish it and on the next day I can complete the rest.
I think we have to stagger it again because we are a bit hard pressed for sometimes. The general will not stay after 1:15.
If he continues,
You have to give him consideration. He always expresses.
I'll try and keep it till 1:15 today.
It's he only when when it's extreme important he'll stay. Otherwise,
this is extremely important for me.
Okay, take down. I'll dispose it now only. Yes. Why you want to quash the impugn show? Why do you impugn show cause notice?
Because we're saying that since our stand is that the marriage was not subsisting, so.
But 10(2) says that anybody who contracts a second marriage during it's a violation of the yes. Take down. the writ petitioner, you were serving as? You're serving as?
Rifleman.
Who was a rifleman?
Rifleman GD.
Who was serving as rifleman, bracket GD, with the respondent Assam Rifles. By way of instant writ application, is seeking to set aside and quash the impugned show cause notice, dated 16/9/2017, and impugned orders dated. Those are discharge orders. Impugned orders dated. Where's that? Which annexure is that? 464/2018.
6418 and 23/518.
That is page.
Will be page 58 and 59.
Those kiski hai? Yes, sir. And orders dated. Orders dated 6/4/2018 and 23. This is appellate order 23/2018. This is appellate order 23.
No, Lordship.
What is this?
This is passed by the DIG, Lordship.
You didn't file appeal.
I have not availed that remedy.
Why? Before the Assam Rifles itself?
We didn't file that. We didn't approach that.
Appeal is there, Mr. Debnath.
Yes, sir.
Why didn't file appeal?
Lordship, initially this is second round of litigation. First round we had approached the Gauhati High Court. That was dismissed because of for one of jurisdiction.
Yes.
So we have straightly filed this. We have not availed that remedy, Lordship.
Who did also? Somna? 6/4/2018 and 23/5/2018, whereby he has been discharged from service. Been discharged from service. You're completely retired.
Lordship.
Completely retired, correct?
Compulsory.
Discharge, huh?
He's been discharged, Lordship.
Compulsory.
Then you allowed pension. You allowed pension.
Yes, pension.
Then
I have not availed because I filed this petition. I'm eligible for pension.
discharge is the main grounds as set out by the writ petitioner are that the respondents.
It is mentioned in 23rd May 2008.
The respondents, while initiating the disciplinary proceedings which had culminated in his discharge, the cause for the same no longer existed. Stop. This contention is founded on this contention by the writ petitioner is that when the offence against which the department proceedings had been run up was that he had contracted a second marriage during the subsistence of the first marriage, and thus had invited the operation of Rule 10(2) of the Assam Rifles Act of the plus the rule of the the Assam Rifles Rules 2010. Stop. Next paragraph. Mr. M.L. Nongpur, learned counsel for the writ petitioner, has submitted that the writ petitioner was duped into a second marriage by we should not give a name, by what whom was duped second marriage during substance of his first marriage, and that the same was dissolved by order dated
Lordship, the order will be 31/10/16.
was dissolved on
10/10/2016
on mutual
divorce. By way of mutual divorce.
being obtained from the court of competent jurisdiction. As such, he contends that on the date, that is 16/9/2017, when the impugned show cause notice was issued and proceedings thereafter commenced, the petitioner was not legally married to any other person except his first wife. He further submits that as in this view of the circumstances, the punishment of discharge from service ordered by the respondents is disproportionate, and prays that this court pass appropriate orders with regard to the quantum, allow him to resume service with the respondent's term. Next paragraph. Mr. R. Debnath, learned counsel for the learned CGC, has only submitted that the order passed by the disciplinary authority given that there is no defect or legality in the order passed by the authority, inasmuch as the petitioner had been offered adequate opportunity and had also deposed and had a very good opportunity to defend himself, and on being found guilty of the offence as charged, had therefore been discharged from service, as the same was in violation of Rule 10.2 of the Assam Rifles Rules 2010. I've heard learned counsels for the parties. In the course of the proceedings, as to ascertain the correctness of the procedure adopted by the Assam Rifles respondents, this court had called for the records of the Court of Inquiry, which have been produced today by the Central Government Council. A perusal of the records as placed clearly show that the writ petitioner had been given opportunity and had also tendered his deposition and have stated the entire facts. Entire facts is noted from the deposition that the writ petitioner did deny the fact that he had contracted a second marriage, though as per his version he had been tricked into the same. In the evidence adduced, the writ petitioner has also deposed that mutual divorce had been filed. He tenders evidence when? If he says it has just been filed. When is the order of mutual divorce passed? Before the show cause?
Before the show cause notice, Lordship. That's why Lordship was trying to impress upon this court that
anyway, yes, sir.
authorities were aware.
So accordingly, it is seen the display authorities then by the, as per the findings of the court, had recorded the deposition and in fact had advised that at reclusion, and it was found that the writ petitioner had contracted a second marriage on 27 May 2014 as per the marriage certificate which had been exhibited. Approval of so further approval of the court inquiry proceedings shows that the approval of these shows that there has been no irregularity, procedural irregularity, or any other infirmity in the said proceedings to warrant any interference stopped by this court. Next paragraph. Rule 10.2 of the Assam Rifles. I keep losing that page, sorry.
Page 54.
Yes. Rule 10.2 of the Assam Rifles Rule 2010 as at Chapter 3 at Rule 10 number bracket 2 thereof has provided as follows. Next para, approval of the as provided by the said rule. The petitioner who had contracted a second marriage during the lifetime of his first spouse, therefore had rendered himself ineligible for retention in service. Accordingly, therefore, for the facts and the facts of the case, no ground for defense will be made out, and the writ petition only stands dismissed. Records are hereby returned to the learned CGC. Yes. Yes. Next matter.
Obliged.
Daily list item 29.
Sasang ka ni? Ano? Unsaan ba? Oy, mo? Pinyo mo ni? Last was in 10 June.
Not sure the last was
10 June.
Yes. Yes.
Lord, Lordships will recall that I had started by assailing this judgment on 4 grounds. One was that the court granted maximum uniform rate as market value without really referring to any methodology.
Yes, maximum account without any
So I had
reason.
assailed the judgment on 4
Reason,
grounds.
erroneous, parity without any basis. Solution granted on the entire amount, not only amount excess of market value.
Lordship.
Excess interest at 12% granted on ordered amount.
For that
15%
first
granted
period?
for the entire period from 2003. Second period after section 4 notification. It's okay.
Lordship. So those were the 4 grounds. So in response, my learned senior has advanced arguments on those particular 4 points. And in addition, he has raised the objection of maintainability on 2 points. One, that the collector did not file his vakalatnama. And number 2, that this is a composite appeal against multiple decrees. So I'll start by responding to these 2 grounds of maintainability, my lord. So the first ground essentially is that in a reference proceeding, the collector is an independent entity and the state government does not have any locus as such. When the collector participates in these proceedings and he engages a lawyer, he must file a vakalatnama. And in support of this proposition, my learned senior had relied on a judgment of 1978, Goa Damandiu. But can you have that judgment? That is at page 27 of the compilation of judgments.
Para 5 and 7.
Yes. Lordship. This is at page 27.
Yes.
So Lordship will see at the very first page that this is a judgment which is passed by the Court of the Judicial Commissioner, not by the High Court.
Yes.
So I was curious to understand why it is the Court of the Judicial Commissioner. So Goa, Daman, Diu are under Portuguese rule. And that time the highest court of appeal was called the Tribunal de Relacao, which after the liberation of Goa in 1961 came to be known as the Court of Judicial Commissioner. And the jurisdiction of the Bombay High Court was extended to Goa, Daman, Diu only in 1981. So this is immediately before the extension of the High Court's jurisdiction. So these were somewhat equivalent, but not entirely the powers of the High Court. Now, this judgment subsequently was set aside in an appeal. I've supplied a copy of the list of books. 1995, 5 SCC, page 333.
Is there a cite?
By the Honorable Supreme Court.
Yes, no, the citation?
1995, 5 SCC,
Yes.
333. Lordship will kindly have page 334. So, Lordship will finally see the name of the parties are the same.
Yes.
And what is under challenge at the bottom, Lordship will find.
Pronounced as Komu what?
Comunidad of Bambolim, as far as I understand. Comunidad of Bambolim. So can you see the bottom, my lords, at the footnote, from the judgment and order dated 28/4/1978 of the Court of Judicial Commissioner Goa Damandiu and application number so and so.
What is decided on 28th March?
Correct. There, I think there's some sort of a mistake, but the appeal number is the same. 138 of 1968.
Okay, right.
And the parties are the same. The subject matter is also the same. So at page 334 is the relevant part, my lord. Para 2.
Yes.
So para 2, fourth line from the bottom, my lord. It begins with the fifth line from the bottom. There is bona fide mistake.
Yes.
There is a bona fide mistake on the part of the council in pursuing the remedy, since the state acts through the council for the state and he is entitled to represent the state in all the proceedings initiated in the court, there was no need to file vakalatnama, but memo of appearance would be sufficient. Accordingly, the order of the Judicial Commissioner is set aside. So this particular order that they were relying on was set aside.
So the judgment goes flat.
Lordship.
Yes. But if you indicate in this SC online, don't indicate was overruled.
But that's the thing. I could not find this particular judgment despite search. It shows this this citation is available, but every time I clicked on it, I could not. This particular judgment was not opening. I'm not sure how they obtained it. This does exist.
Of course.
Ideally, it indicates that it's been set aside.
Because it's not available anymore. Yes.
Lordship.
Before, when the earlier SCC online was there, suppose when you click to the judgment, not this, I mean, Supreme Court even overrule or you know.
Yes, it would say.
It came on red, you know.
Correct.
It's been dissented.
So I could not find this.
Yes.
It's the next judgment that I'm relying on is the case of Sharda Devi vs. State of Bihar, 2003, 3 SCC, page 128.
Which one?
2003.
Yes.
3 SCC 128.
Yes.
The relevant page is at page 146, para 33.
33.
Yes, at page 146. Lordships have it.
Yes.
This reads, the collector acts as a representative of the state.
1 second.
Para 33.
Yes.
Para 33, my lord. The collector acts as a representative of the state whilst holding proceedings under the Land Acquisition Act. In fact, he conducts the proceedings on behalf of the state. The award of the collector is not the source of the right to compensation. It is the pre-existing right which is recognized by the collector and guided by the findings arrived at determining the objections, if any. The collector quantifies the amount of compensation to be placed as an offer of the appropriate government to the owner recognized by law. So he's acting on the instructions of the state. He's very much a part of the state. So it cannot be said that the state is alien to these proceedings. And in view of that, the collector becomes a public officer within the meaning of section 2, subsection 17 CPC, therefore is entitled to be represented by a government leader.
Just that he's a representative of the state, that's all.
Lordship.
It's held that he's a representative of the
Yes.
state.
So the very position taken by the respondents that the collector is an independent entity, cannot be represented by the state council, stands negated by these two judgments.
Yes.
So I would submit that this particular point on maintainability does not have any basis. There's a second point was the issue of maintainability of the composite appeal.
Yes. Yes.
So the respondent's proposition here is that since there are multiple decrees, therefore there should be consequently independent appeals. Now this follows from the general understanding, the conventional understanding of regular suits. Yes. When there are multiple suits and they are consolidated by some sort of an order, they go through a common trial, common evidence, and they are disposed of by a common judgment. There, the courts assign they drop multiple decrees, individual decrees for those individual suits. And that's the general proposition. Now the question is, how does it apply in this case? Because the facts are very peculiar. Now my learned senior has relied on a judgment of, kindly have the compilation again, yes. At page 1, the judgment of Gangai Vinayagar Temple. It's at page 1. Yes. The relevant page is page 23, running page 23.
Yes.
Para 27, my lord,
Yes.
is what is relevant that they have read out. Procedural norms, technicalities and processual law evolve after years of empirical experience, and to ignore them or to give them short shift inevitably defeats justice. Where a common judgment has been delivered in cases in which consolidation orders have been specifically been passed, we think it is irresistible that the filing of single appeal leads to the entire dispute becoming sub judice once again. Consolidation orders are passed by virtue of the bestowal of inherent powers on the court by section 151 as clarified by this court in Chitivalasa, Jute Mills. In the instance of suits, kindly take note, Millards, there were multiple suits therefore. In the instance of suits in which common issues have been framed and a common trial has been conducted, the losing party must file appeals in respect of all adverse decrees found even on partially adverse or contrary speaking judgments. I've gone through the facts of this case. There were multiple suits. It's not a case where there was a single suit and there were multiple plaintiffs. Now kindly consider a case, there's a suit where 3 or 4 brothers go to court asking for their share. So there are 4 plaintiffs, 4 defendants. And the 4 plaintiffs are successful. Would the courts give them 4 individual decrees? It will be a single decree. They can't say therefore that the losing party will file 4 different appeals, because the parties have come to court together in one single list, not in individual cases. In this case, there were multiple suits and there was a consolidation order which was passed. So again, my lords, there's a reference here of the judgment of Chitivalasa, Jute Mills. And you have that judgment as well. 2004, 3 SEC. Let's kindly have page 89.
Para?
Para 12, page 89. Para 12, 1, 2. 12. This is read, my lord. Para 12. The 2 suits ought not to be tried separately. Once a suit in Rewa has reached the court at Vishakhapatnam, the 2 suits shall be consolidated for the purpose of trial and decision. The trial court may frame consolidated issues. The Code of Civil Procedure does not specifically speak of consolidation of suits, but the same can be done under the inherent powers of the court flowing from section 151. Unless specifically prohibited, the civil court has inherent power to make such orders as may be necessary for the ends of justice to prevent abuse of the process of the court. Consolidation of suits is ordered to meet the ends of justice as it saves the parties from multiplicity of proceedings, delay and expenses. Complete or even substantial and sufficient similarity of the issues arising for decision in the 2 suits enables the 2 suits being consolidated for trial and decision. The parties are relieved of the need of adducing the same or similar documentary or oral evidence twice over in the 2 suits at 2 different trials. The evidence having been recorded, common arguments need to be addressed, followed by one common judgment. Now kindly take note of this, my lord. However, as the suits are 2, the court may, based on the common judgment, draw 2 different decrees or one common decree to be placed on the record of 2 suits. So even this convention is not really mandatory. So in this case itself, the court orders that although there are 2 different suits, they don't have to necessarily result in 2 individual decrees. There could be a single decree. Now, for the application of this general convention, which is followed in civil suits, we have to see where is the similarity of facts here. Now, in this case, my lords, what we need to examine is, if there is a suit, what would correspond to a suit in a proceedings under section 18? So if your lordships have the Land Acquisition Act, section 18. Since there is no plaint here, we'll have to see what would be the starting point of the proceeding and what would correspond to a plaint. Because under Order 4 CPC, a suit is commenced by way of a plaint.
Yes.
Well, it's section 18 falls under part 3. And kindly see the heading of this particular part, reference to court and procedure thereon. So the entire procedure for the reference proceedings through the collector till the court is covered by section 18 to 28. May I just read, my lord?
Yes.
Reference to court. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court whether his objection be to the measurement of land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation among the persons interested. So therefore there are two things. One, there has to be a written application and there has to be an objection on either of these four grounds. Thereafter, kindly see subsection 2. The application shall state the grounds on which objection to the award is taken. And then if I just take your lordships to section 19. Collector's statement to the court. So as soon as the collector receives a written application raising the objections to the award,
yes,
this is the procedure to be followed by the collector. This reads, collector's statement to the award. In making reference, the collector shall state for the information of the court in writing under his hand, and kindly see subclause D, if the objection to be to the amount of compensation, the grounds on which the amount of compensation be determined. So essentially from a reading of section 18 and section 19, I would submit that the starting point of a proceedings under part 3 is a written objection which contains objections, and that therefore necessarily would correspond to a plaint in a civil suit. And this is the starting point. So in these particular facts, lordship will notice from the paper book 1, their application for reference. Page 96.
Yes.
So this is addressed to the collector. This is the application. Kindly see the cause title. An application under section 18 of the Land Acquisition Act for making a reference to the special court. Now kindly see the parties. Sri Armstrong CM, son of so-and-so, resident of so-and-so, Umroy district, and other landowners whose land have been acquired by the government for construction. Now this was signed apparently by 137 people, which is stated at para 1.
Okay.
So this is a joint application. It reads at para 1 that the petitioners, landowners, numbering 137 approximately, are the residents of the owners of so-and-so area, and they are the parties who have signed and filed this application. So a joint application signed by all the parties. On the basis of this, the collector made the order of reference. So, in my humble submission, this application under section 18 would have to be treated as what corresponds to the suit, the plaint. Now, whether it has been filed in representative capacity, we can see that from the pleadings itself. There has been a mention in the earlier set of proceedings that he's filing it in representative capacity. And I'll come to that a little later. But this, in my humble submission, has to be treated as a starting point of the proceedings under section 18. And kindly see at page 107 is the reference order by the collector. So I'll just refer to the first paragraph. With reference to the above, I have the honor to forward herewith an application under section 18 of the Land Acquisition Act, filed jointly by one Armstrong CM of so-and-so and 67 others. So there was only one single reference order which was made by the collector to the special court. This is also a very vital point.
There's only one single reference order.
Yes, my lord. So one single joint application and one single reference order.
Yes.
On the basis of this application, the reference order, the special court registered only one case. It was not that they were split up individually. There was only one case which was registered and subsequently renumbered when it was transferred to Nongpo. This is another very vital issue.
This was taken on Shillong at time.
Initially at Shillong, and then
only one reference case was registered.
Only one. Lordship will find at page 119.
Oh, that's interesting. So the genesis is one.
Yes, it's just one. That is why I would say that these case laws cannot necessarily apply to this case. Even a small change of facts results in a completely different outcome. At page 119 is a copy of the judgment. Lordships will find the reference case numbers. Reference LA case number 122 of 2015. This is the new number assigned in the court in Nongpo. And the old number was LA case number 8 of 2003. Only one single case, and the cost title reads accordingly.
No,
Sri
but
Armstrong
before Nongpo also says, C. Armstrong Stain 67 others.
67 others, exactly. It was only one single case. It is not a case, this is a misnomer to call it a common judgment. It is a regular judgment. It is not a question of consolidation of multiple reference cases into one. There I understand what could say it's a common judgment. This is a regular judgment.
But you see only one thing, the separate decrees were given.
That's the interesting part, my lords. Now, let's examine that. In all the other cases that have been referred to, lordships will find the separate decrees bear the numbers of the individual case numbers. So if there was title suit 1, title suit 2, title suit 3, they are clubbed together. When the decrees are passed, the first decree will bear the number of the corresponding title suit number 1. Now look at the decrees here at page 326. They all bear the same number.
Was that correct?
Yes, my lord. There can't be a separate number again. Page 326.
Yes.
So kindly see the case number again. They replicate the same case numbers. LA case number 122 of 2015 and the old number. And kindly see another decree, which is at page 334 for another claimant. Again, lordships will find the same case number. So all of them have been assigned the exact same case number. So this is also something which is unknown to law, that the trial court had to issue multiple decrees. So perhaps this was done for the sake of convenience or at the request of the claimants. But in any case, perhaps because there were different calculations. So on the facts of this, lordship will see that it is not similar to any of these other cases. Now, another interesting part is the conduct of the claimants themselves. Kindly have page 784. 784.
Right at the end.
Lordship. $784.
Yes.
Because once this judgment was passed, I believe at the time of drawing up the decree, the claimants noticed that there was an error, which they termed as an arithmetical or a clerical error, where solatium was recorded as solatium per annum, 30% per annum, which is not permissible. So the claimants filed this application, which is miscase number 2 of 21, seeking that correction.
Yes.
So again, Veluts, here
they referred one
singular application. So case is disposed of. If they have to follow the same thing, individual application should have been filed. They filed a joint application.
Filed on?
This is filed on It doesn't say. Sometime in March 21. From the affidavit, that's what transpires. So kindly see the cause title of the parties. Armstrong CM, one of the landowners petitioners and representative of all petitioners in LA case number so and so. Then he goes on to say at para 1.
But why did they quote the old number then?
They were quoting the old number as well as the new number.
From Shillong.
Correct. They should have quoted the new number here. Kindly see para 1 here, my lord. That the applicant herein is one of the landowner and claimant number 1 in LA case number so and so 2003, and besides the other claimants, petitioners in the meeting held on 27/9/2002 selected the applicant along with 2 other persons, namely Sri Mauramsong H. Blah and Sri Baston S. Lingdo, to act on their behalf. Thus, the applicant has the authority and right to file the incident application not only on his behalf, but also on behalf of other claimants in LA case number so and so. And a copy of the aforesaid meetings is enclosed. So, on the basis of this, can you also see the affidavit at page 787? Para 1, the second line says, I say that I am duly authorized and competent to file this instant application not only on my behalf but also on behalf of the other claimants. Anyway, on the basis of this, this application was disposed of, and the court substituted that finding of 30% per annum, and it should be read as 30% as a one-time measurement. So, looking at the facts of this case, we can't say the claimants are trying to take advantage of this whole thing. They file a singular application under Section 18, and they're all single.
So, what's sauce for the goose, sauce for the gander?
Lordship, exactly. They can't turn around and take advantage of the fact that I have filed a singular appeal. I have rightly filed a singular appeal. What else could I have filed?
The reference also will be, will be what do you call it, unmaintainable if that's the case that espousing here.
Lordship.
Yes, anyway.
So this is one part. Now, in this particular issue, my learned senior had referred to another judgment. 2007-14 SEC.
It's not here in the compilation?
This was an additional judgment that my learned senior had supplied, not part of the compilation notes, but I've given it in my list of books. This is Union of India versus Ranchod.
Yes.
My lord, my learned senior had referred to para 12, which is at page 331. Lordships have it?
Yes.
I'll just read this out. Kindly see the facts in this case. In the case in hand, the High Court has not referred to even an iota of evidence which was adduced by the parties. There were a large number of landholders whose land was acquired, and they had filed separate objections under Section 9 of the Act and had separately sought references under Section 18 of the Act. They had separately led evidence in support of their cases before the reference court. It is not a case where a single case may have large number of parties and the evidence adduced is common for all of them. This falls in the second category, where there is only one single reference application. So this judgment again does not help the case of the claimants. Factually very different.
Yes.
Well, the only difference factually in this case is something that has been added to the proceedings by the claimants. In addition to the reference objection under Section 18, once the matter reached the court, what the claimants did, and this is particularly to clarify to the court what their individual claims were,
Yes.
They filed individual claim petitions. Lordships will find this at paper book number 2.
Yes.
So I will refer to only one of these applications. So Lordships, kindly see at page 1. This is filed by. So the cause title is again very interesting. The court of so-and-so, matter of LA case number so-and-so, Armstrong, CM and 67 others versus Collector Ribha District. This is the cause title of the case. And then in the matter of a claim petition of the petitioner, and then the name of the parties individually.
Yes.
And what their individual case was, they espoused through these claim petitions. Now the question is, this cannot partake the character of the plaint. This cannot correspond to the plaint, number one, because this does not find mention in the procedure under section 18 of part 3. An independent claim petition is not provided for. Nowhere does it say that after the section 18 reference is made by the collector to the special court, a party can file an individual claim petition.
Yes, what are you saying? Sorry.
It's under that procedure which I was referring to in part 3 of the Act. Part 3 conclusively lays down what is the procedure upon filing a section 18 application. And that entire procedure does not contemplate filing of a claim petition. That original reference objection which is filed before the collector, that becomes the foundation for the entire proceedings. This is supplementary, not recognized anywhere by the entire Land Acquisition Act. So I anticipate that my learned senior may raise this issue to treat this as a plaint, but that cannot be treated. Because the cause title of the case is only one single case.
I think stems from reference.
Yes. So this may have been filed for the convenience of the parties and the convenience of the court, but this does not have any legal recognition. And lastly, Lordships have already noticed that despite raising such a vehement objection, the claimants themselves, 47 claimants, have filed a singular cross objection. So while they raise this objection so vehemently, they have themselves tried to maintain their own cross appeals, and they have already argued that on merit. So I would humbly submit this point, although it sounds good at first blush, it sounds like a point that needs to be gone into. But if your Lordships look at the facts of the case, the peculiar facts, they're very different from any of the other cases that have been cited by the claimants. And there is actually no precedent on this particular issue. So Ranchhod in fact clears out the two categories of cases. One category is when there are multiple section 18 applications. And then when there's one case where there are multiple different landowners, but they come to court by a singular application. So in that case, there is no question of filing individual decrees. And it's very surprising that all the decrees bear the same case number. So where is the question of filing subsequent individual appeals? That again is a procedure which is unheard of. Now on the merit, my lord, the first point that I had argued was that the court granted maximum uniform rate while determining the market value.
On merits. We take next statement.
Lordship.
Yes.
These 2 points itself took about 45 minutes.
Yes, 45 minutes. No, because very interesting. The first point regarding the wakalat by collector. Yes. That was because usually the collector is taken as a as a distinct entity in acquisition matters. He is not linked to the government at all because he's exercising his power more or less in the independent fashion. So that's the thing. So even that is why when the notice is issued, also doesn't mean that the government advocate accepts notice automatically.
In fact, in the reference proceedings, the GP appeared. The government pleader appeared before the trial court. I don't know if they raised their objection there. So all throughout, it's the government pleader who's representing the collector in these proceedings. In fact, that's the same case in all the other districts as well. Even in East Khasi, it's the government pleader who represents the collector by default.
This practice has been done away. Now, when I started raising objection in Joy, now they are not, government advocate is not allowed to plead.
Joy?
In Joy. So
Which
many
is NIPCO
cases are
matter?
there. then collector has appointed specifically his own lawyer.
But Miller, that maybe because of that judgment of 1978, but that's set aside. And in Sharda Devi, they make it very clear that he's only offering as a representative of the government. That's the price that he's offering. He's still part and parcel of the government.
Yes, other call other hearings.
39.
What date will your
Just
lordships
for
assign?
hearing, yes.
What date will your lordships assign?
You can continue.
Tomorrow?
Continue next week better.
Up to your lordships. I'll leave it to your lordships.
Your lordship will give a date because
Next week we'll continue with this on. Next week will be
Monday. Monday lordship.
Yes.
Monday. I'll leave it.
Monday is the first.
First.
Is that a holiday? No.
Third is
No, not holiday.
Third is a holiday, right?
Obliged.
39.
Yes, Mr.
Lordship, Lordship, in this matter, on behalf of learned DSGI, I am praying for some accommodation, Lordship.
You was here whole morning?
Yes, Lordship, due to some urgency.
2 o'clock.
Yes,
Yes.
Lordship, due to some urgency, he had to leave.
Short date may be given, Lordship. Otherwise,
1
my
week's
seniors
time
will
may be given, Lordship. 1 week, after a week.
Okay, request of parties is up to 1 week.
Highly obliged, Lordship.
40. 40.
Last time also, what's happened to Mr. Jha?
My lord,
He is on sanction
leave.
leave.
The supplementary cost is we can see that.
Okay, as the council petitioner thought, note down. Note down. First one was request of parties, less of 1 week. Ganepa as the counsel for the petition of sanction leave. This is matter after 2 weeks, yes.
Highly obliged, Lordship.